I'm sure the first question that you all have about ladybird deeds is why you had to get up so early to listen to this. I can't answer that question. I didn't do the schedule. But you might ask the next question is why are we even talking about ladybird deeds? I mean, after all, they've been around for 20 years, 25 years. A lot of people use them. Probably most people in this room have done a ladybird deed, probably several of them. And the interesting thing is, if you stop to think about it for a minute, we've been doing it for 20, 25 years, but there are no cases. I don't know if anybody has a case on ladybird deeds other than the 1911 Oglesby case, but I don't have any cases on them. So we've been doing them for all these years, and we always read the fund articles. They've written several articles on ladybird deeds. I've included that in your appendix. And you see when you read it, they tell you, well, you can do this, but you can't do that. You can't insure title. We won't insure title here, but maybe we'll do it in another situation. And it's not as if you have all these cases that really tell you anything about them. It's more like as we talk about this sort of title insurance law, as we sort of joke about it, because it's a matter of risk. If you don't know the answer, why would you insure a risk? Of course, we all do that every day. We walk across the street and we don't know exactly what's going to happen, whether we'll get hit by a car or not, but we assume that risk or else we're not walking across the street. So obviously, a title insurance company has the same concept. There's certain risks they're going to insure and certain risks they're not going to insure. And if you don't have a case or a statute that tells you this is how something works, then it's a matter of trying to calculate risk. And it seemed interesting to me that we've gone so long without cases that maybe we need to revisit the whole issue of ladybird deeds and how we use them. And maybe there are things that should be allowed that we can't do now. And maybe some things we should continue to draft the way we're drafting them. Since there's been this increased use in ladybird deeds, and we have this increased use in ladybird deeds since the last 20, 25 years. Everybody's been using them. And mostly in elder law and estate planning. And so we see that as probably the primary uses. I can't think of really another use, at least I don't use it for any other reasons. But what's happened, in addition to the fact that we haven't seen any cases, is we start seeing these creative uses of ladybird deeds. That is to say, a lawyer gets an idea and he says, I think I'm going to add something to this deed, and it seems okay to me, and he runs it by his colleague, and colleague could probably care less and say, yeah, it sounds like a great idea. Next thing you know, they wind up with an uninsurable title. And we're all lawyers, and because we're lawyers, we have this sort of creative nature about our drafting, but can get us in trouble. And so, as a result of that, you really have to sometimes go back to the beginning, review the law as we know it, review what the fund says, this is a permissible practice, this is not, this will get you in trouble. And by doing it this way, you can do the type of work that will basically keep you out of trouble, but be a service to your client. And so what I did was I put this program together in kind of 4 little parts, even though it's a small program to begin with. One is a general introduction, which will sort of put everybody on the same page. And then what I call the fund's position. But I want you to understand, when I say the fund's position, I'm not speaking for the fund. This is my interpretation of what I believe the fund thinks based on the articles they've written, letters that I've gotten back and forth to the fund and from other fund members who have consulted with me and have sent me letters that they've received from the fund. So this is what I believe the fund's position is. If there's any question, you should always check with the fund. I mean, you can look at my material, but if you're doing something you're not sure, always check with the fund. And even if I'm correct, that doesn't mean that the fund won't change their position on something. Even writing my material, I was emailing back and forth with one of the senior underwriting attorneys, and she added to what had already been in print, but basically without her embellishing it in her email, I would not have known that the fund had a different position or had expanded it. So you always have to be checking with them. So we have the fund's position, what I call drafting techniques, which is just some basic things you should know about drafting, and issues that I call sort of contentious or unresolved issues at the end.